So this case does not begin with a rule violation. It began with a lawyer who believed his client was innocent. When Jeffrey Wertz was appointed to represent Russell Jolliffe, he stepped into a case that was emotionally charged and publicly serious. The allegations were grave, but the evidence was thin. There was no forensic evidence, there was no medical evidence, there were no eyewitnesses. The Commonwealth case relied entirely on testimonial account of a young complainant, a story by the investigating officer's own admission that had changed multiple times. The timeline had shifted, the location had shifted, the description of how the conduct allegedly occurred shifted. And critically, with each version, there was objective evidence demonstrating that the conduct as described was not physically possible under the circumstances alleged. And Attorney Wertz did what defense lawyers are constitutionally required to do. He investigated, he scrutinized the timeline, he compared prior statements, he examined the physical realities, he tested whether the allegations aligned with what could have actually occurred. He spoke at length with Russell Jolliffe. He later spoke at length with Joanna Wheatley. He listened to hours of recorded calls. This was not a case where co-defendants were blaming one another or where one sought an advantage at the other's expense. This was a unified defense. It didn't happen. When the cases were initially joined, there was a theoretical potential for conflict, as there always is when there are two co-defendants and they are tried together. But when the court severed the matters on February 3rd, that theoretical risk dissolved. The defendants were no longer co-defendants in a joint trial. They were separate defendants in separate proceedings, each maintaining the same defense, innocence. What happened here was not misconduct. It was a lawyer appointed at modest hourly rates defending a client he believed was wrongfully accused, challenging a prosecution built solely on shifting testimonial evidence, and attempting to present evidence he believed was exculpatory. There is no evidence here to find violations. And to find violations, you must find not that you think this might happen. You must find clear and convincing evidence, evidence that leaves no serious doubt that Mr. Wertz knowingly violated these rules, that he couldn't form an attorney-client relationship with Ms. Wheatley that permitted communication with her, that he was barred from assisting a former client in any limited fashion after disqualification, and that his representation was incompetent. The Office of Disciplinary Counsel has no evidence that meets that standard. And the proper result here, under the rules, under the evidence, and under the burden of proof, is dismissal of this matter.
Can you please state your name for the record and spell your last name?
Brandon Neuman, Neuman.
And what position do you presently hold?
I am a judge on the Pennsylvania Superior Court.
On which court, if any, did you previously serve?
As of last year, I was on Washington County Court of Common Pleas.
Please turn to what's already in evidence as ODC 12. That's a motion to disqualify counsel Mr. Wertz. Is that correct?
Yes.
Was it your understanding that that motion was in the nature of an emergency motion?
I can't remember exactly, but because of the closeness to the trial, it very well may have been.
And do you recall that proceeding? There was more than one issue was before the court on that date.
I mean, I know that this is the transcript. I'm not familiar with everything that happened at that hearing at this moment.
But this proceeding was scheduled before even the emergency motion or motion to disqualify had been filed, correct?
So I'd have to read through the whole transcript to tell you that, but I can tell you that prior to trial, we do have scheduled days, and so it would not surprise me if there was already something scheduled and this was added on.
But you do recall this was the proceeding in which you entertained the motion to disqualify Mr. Wertz.
Yes.
Was that filed while you were still proceeding or presiding over Mr. Jolliffe's criminal case in Washington County, correct?
Yes.
Identify this for the record, please.
It's titled as Respondent's Initial Motion to Disqualify Judge Neuman from Presiding over Contempt Proceedings. It is filed by Mr. Wertz. It is an order of sentence dated March 1st, 2024 in the case Commonwealth of Pennsylvania versus Russell Jolliffe.
And what was Mr. Jolliffe sentenced to?
It was the sentencing after being found guilty at a jury trial.
What was his sentence, if you recall?
I'll just say the aggregate sentence of confinement for not less than 45 years and not more than 90 years of incarceration.
My name is Sam Zapala. I currently work as a Deputy Attorney General in the Pennsylvania Office of Attorney General.
And you were admitted to practice law in Pennsylvania on January 4th, 2021, right?
That is correct, yes.
And you began working at the Washington County District Attorney's Office in January of 2021, correct?
Yes, ma'am.
When did the Jolliffe case start?
I don't remember the specific date. I'm sorry.
Was it mid-2021?
Yeah, that sounds about right.
You were assigned to the Jolliffe matter on February 1st, 2022.
Yes, that sounds correct.
When was Mr. Wertz appointed to the matter?
I believe he was the third attorney appointed on that case.
Was Mr. Wertz on the case when you were assigned?
Yes, ma'am.
And when you were assigned to the Jolliffe matter, you were pretty early in your career as a prosecutor, correct?
Yes, I was probably a year or two in.
Before that assignment, had you tried many cases to verdict?
At that point, I probably had 5 jury trials.
Had you handled any sexual assault jury trials to verdict at that point?
No, ma'am.
So on January 14th, 2022, your office subpoenaed the jail for inmate telephone calls for Russell Jolliffe and Joanna Wheatley, correct?
Yes, ma'am.
And those calls were turned over to your office about January 18th, 2022, and placed in your office's possession, correct?
I don't know the specific date, but yes, they were given to us.
Well, if the Washington County jail says that's when they turned them over, would you agree with me that was when they turned them over?
Yes, ma'am.
On 3/11/2022, you sent an email to Mr. Wertz and to Josh Carroll and then provided the defense those calls on a thumb drive, correct?
Yes, ma'am.
And then on March 21st, 2022, you learned that the production contained at least 8 attorney-client calls between Mr. Jolliffe and Mr. Wertz, correct?
Yes, ma'am.
You immediately understood that attorney-client calls are presumptively privileged and highly sensitive, right?
Yes.
The day after, he called the DA's office and emailed the DA's office and had asked the DA's office to recuse. You issued another subpoena seeking additional jail calls since January. Do you recall that?
I do not.
This is a subpoena dated March 22nd, 2022. Your name is on it again. Does that refresh your recollection that one day after receiving notice that you had possession of attorney-client privileged and confidential calls between Mr. Wertz and Mr. Jolliffe, you issued another subpoena asking for more calls?
Yes, ma'am.
And you would agree that issuing that subpoena would risk obtaining more privileged communications?
Well, I don't find them privileged communications.
And then you issued a subpoena for more calls.
That's what it seems like, yes.
You actually got approximately 60 more calls in that second batch, correct?
I don't remember, but usually these jail calls, if we request a long time period, it's a lot of calls. It was probably 60 calls. That does sound right.
Are you aware that there was a lawsuit filed related to the recording of the calls?
Yes, ma'am.
And are you aware that Washington County has resolved that case and acknowledged they were reported improperly?
I am not aware of the civil case, no.
Do you have ODC 14 in front of you?
Yes, ma'am.
Read what that order says regarding what Mr. Wertz was precluded from doing.
It states, further, defense counsel is precluded from representing either defendant Russell Jolliffe or co-defendant Joanna Wheatley in any criminal proceeding related to this case.
Does that say anything about speaking with Mr. Jolliffe?
No.
But rather than seeking clarification on that issue, you sought criminal contempt.
What was happening right in front of me in the courtroom, I had to bring it to the judge's attention. That motion was filed later that day, so I actually didn't have access to this transcript. I would have amended some of the language a little bit. He was still giving legal advice.
Are you aware of Rule 1.16, the rule of professional conduct?
Not off the top of my head, no.
Are you aware of a lawyer's duty when their representation is terminated, their duty to successor counsel and to their client?
No, ma'am.
Did you ever at any time correct your statement that Mr. Wertz was involved in the filing of the brief?
No, I did not. Not in the motion, I didn't get to.
In the criminal contempt proceedings, when they were docketed under the miscellaneous docket, was your motion for contempt refiled?
Honestly, that's after I left the office, so I don't know the procedural posture for that.
Right, but you authenticated the docket in that case. Did you review the docket in that case?
Yes, I saw it was a miscellaneous docket number for the contempt. I didn't take part in refiling it under that MD number, though.
Did you notify anybody in the DA's office that your motion to disqualify was factually inaccurate?
No. But I mean, we had a hearing on this.
I'm sorry, the motion for contempt.
No.
Who made was it your personal decision to seek criminal contempt, or was it of somebody else in the DA's office?
That was my personal decision in the moment.
Was anybody else in the DA's office involved?
Yes, John Freeman was involved, but he was involved in the subsequent proceedings. He wasn't involved in the initial filing.
In the decision?
Correct.
I think you said you were aware that Mr. Jolliffe and Mr. Wertz sued the county and others related to the recording of their attorney-client calls and the access to that information by the DA's office?
Yes.
Mr. Wertz actually told you he was going to do that, didn't he?
Yes, he did.
So my given name is Joseph Carroll, Carroll, but I go by Josh.
And what is your occupation?
I'm an attorney. I work in the public defender's office.
In Washington County?
Yes, sir.
I provided you with pre-marked exhibits previously. I've provided
Yes,
you with a binder of ODC's exhibits today. Do you know the respondent in this matter, Jeffrey Wertz?
Yes.
And how do you know him?
He was on a case I had with a co-defendant.
And who did you represent in the matter?
Joanna Wheatley.
And did Mr. Wertz approach you about something?
Yes.
And what did he ask?
He asked if he could speak to my client.
And this was directly after a criminal proceeding?
Correct.
On that date, when a motion in your client's criminal case was heard, what was your understanding of what Mr. Wertz was asking you to consent to?
My belief was that he was asking if he could speak to my client in preparation for the trial.
What was the nature of Mr. Wertz's email and what was your response?
He was, I don't know, it says, well, that was interesting. I'm assuming he's referring to the hearing. Would you please give me a call? He wanted to get any exhibits or documents I have that might assist him. He told me that my client had informed him directly she does testify. And then my response to that was, I've instructed her not to testify. And if you intend on serving with subpoena, send it to me. I withdrew my consent to speak to her at that time.
Did he ever have your consent to speak with Ms. Wheatley about her PFA matter?
No, that never came up.
Did Ms. Wheatley ever express to you that she wanted a different lawyer to represent her in her PFA matter?
Ultimately, she did.
And when was that?
That would have been after the February 3rd.
After you had been appointed to represent Ms. Wheatley in her PFA matter, did you appear on her behalf in any PFA proceeding?
I don't think I ever appeared in any PFA proceeding for her. That, to me, was secondary and tangential to the criminal case. So we would continue those with consent orders.
Exhibit YY.
Okay.
Do you recognize that as her handwriting?
Well, I don't know if that's her handwriting or not. That looks like her signature, but
How many handwritten letters did you get from her?
I don't know.
What's the date on that letter?
It's stamped August 20th of 2022.
In that letter, she stated she wasn't receiving a fair trial and requested new counsel.
Yeah, she requests to get rid of the DA, and then
She also requested to get rid of you. She had asked you to get medical records in the kit, correct?
in this letter,
No, she had asked you before. She says in that letter she'd been trying to get.
Yep.
You hadn't got. Did you ever get that information for her?
I don't believe there was any.
How about medical records?
I don't recall if we got, I don't think we did get medical records. For her case, no, we didn't.
But she had asked.
She had asked for those.
Is that because the medical evidence wasn't consistent with the allegations?
Yeah,
Did you talk to Ms. Wheatley before withdrawing consent?
yes.
You tell Ms. Wheatley that you were doing that?
Without getting into specifics, we discussed her testifying at Mr. Jolliffe's trial.
No, I'm talking about, did you talk to Ms. Wheatley before you withdrew the consent and after this email to tell her you were going to withdraw the consent? Not about testifying.
Okay.
About withdrawing consent.
I don't recall if we discussed that specifically.
You sent him an email between you and Mr. Wertz that said you had instructed her not to testify and you revoked consent. You sent that to Mr. Zappala.
I must have, I don't know, it was part of the motion.
He attached it to his motion.
Yep.
Did you have Ms. Wheatley's permission to share those communications?
My communications with Mr. Wertz,
Yes. Your communications about her case.
I don't know if we discussed that or not. I don't recall.
Okay.
My name is Joanna Christine Wheatley.
You are sometimes called JoJo, correct?
Yes, that's what everybody calls me. They call me JoJo.
How do you know Mr. Wertz?
He was on my ex-fiance Russell Jolliffe's case. He was his attorney.
Was Josh Carroll appointed for both your civil PFA matter and your criminal case?
He was on my criminal because he told me he was not able to do the civil because he cannot do a PFA case.
Did he actually enter his appearance in the PFA case?
From what my notice is, when the hearing would come, he would tell me he's just going to postpone it.
So he was representing you in the PFA case.
Yes.
Were you satisfied with his communication with you?
No, I was not.
Did you complain about that?
Yes, I did.
Some point, did you write to the court asking to remove him?
Yes.
Is that your handwriting?
Yes, that is my handwriting.
You wrote that and sent it to the court and to Josh Carroll.
Yes.
How did you first come in contact with Jeff Wertz?
It was sitting in the booth right next to the judge.
The jury box?
Yes.
Do you recall when that was?
I believe it was in October.
Of 2022?
Yes.
Did you hear Mr. Carroll give Mr. Wertz permission to speak to you?
Yes.
Do you remember, were there any time limits or limits on what you could talk about placed on that permission?
No, there was no time limit, or he actually told me if I have permission to talk to him anytime I wanted to, if there was something I needed to let him know that would help the case.
Mr. Carroll told you that.
Yes, Mr. Josh Carroll told me that.
Did he tell you it was your decision when you wanted to talk to Jeff and what you wanted to tell him?
Yes.
Did you ever tell Mr. Carroll at any time that you didn't want to speak with Mr. Wertz?
No, because I've always wanted to talk to him.
Did Mr. Carroll tell you any other time that you were allowed to speak with Mr. Wertz?
No. Basically, he told me that I could talk to him anytime that I needed to tell him information about the case.
How would you describe your defense and Russell's defense?
The same.
Did that
It was all
ever
the same.
change?
No.
Did you ever at any time tell Mr. Carroll you plan to take the fifth?
No, I did not.
Did you
I did
ever
not.
tell? Sorry, go ahead.
I did not agree to that. No, I never told him that.
Did you ever tell Mr. Carroll that you were considering taking the fifth?
No, I never said anything like that to him.
Mr. Carroll told you he thought you should, though, correct?
Yes, and I told him no.
And did you tell him, despite that, you were going to testify anyway?
Yes.
Did you ever become concerned that Mr. Carroll was going to try to stop you from testifying after the cases were separated?
Yes.
Do you recall being in the jury box in the courtroom on February 3rd when the court separated Russell's and your cases?
Yes.
After the cases were separated, do you recall speaking with Mr. Wertz?
Yes.
Did you discuss at that time with Mr. Wertz that you wanted to testify for Russell?
Yes.
Did you ask him at that time if he would represent you in the criminal and PFA matters?
Yes.
What did he tell you?
He told me he can do the PFA, but he cannot do my criminal case. He would wait until after Russell Jolliffe's hearing went through and see what was going on with him, and then there could be a possibility he can do my criminal case.
Had you ever asked him prior to that time in the jury box to represent you?
Yeah.
And what did he tell you then?
He told me then that he's not sure because he doesn't want to step on nobody's toes and he would have to see how things go.
Did he tell you that he couldn't do it while the cases were joined?
Yes.
Is that why you asked him again after they were separated?
Yes.
Did Mr. Wertz believe that your testimony and Russell's testimony were completely aligned?
Yes.
And Mr. Wertz agreed to represent you in the PFA matter in the courtroom immediately following the hearing.
Yes.
Do you see that document?
Yes, I see it.
Is that your signature there?
Yes, that is my signature.
And did Mr. Wertz go over that document with you?
He went over it twice with me to make sure I understood everything.
Do you remember at any point after that jury box discussion, but before the disqualification of hearing of Mr. Wertz, did you tell Josh Carroll that you were even thinking about not testifying or taking your Fifth Amendment?
No, I never said anything like that to him.
If Mr. Carroll told the court or anyone else that you were going to take the Fifth, that would be incorrect.
Yes, that would be incorrect.
And did you voluntarily sign a witness subpoena to give testimony for Russell Jolliffe?
Yes, I did.
Did you tell Mr. Carroll to challenge any subpoena?
No, I did not.
Joanna, why did you want Jeff Wertz to represent you?
Because he's a trustworthy attorney. He's somebody I can actually trust. Compared to Josh Carroll, he didn't do nothing I wanted him to. I couldn't trust him. When you're with a client and you have an attorney, you're supposed to trust the fact of trusting your attorney to know what he's doing and to know that he can trust in you, that you're telling him the truth when you know you didn't do something. And he always trusted in me and Russell and knew that we were innocent.
You entered a plea agreement in the criminal case against you, correct?
Yes.
That was right after Mr. Jolliffe was convicted, correct?
Yes. I entered a plea agreement because I knew that how long he was going away for, that's what they would have gave me, because we were arrested together and I wanted to get home to my kids, and I figured while I was on the outside, I could help him. If he had a retrial, I could help him get the information he needed to fight his case because he is an innocent man.
Did you watch Mr. Zappala's testimony this morning?
No, I had no idea he was testifying. I've watched nothing. I just signed on and
You were admitted to practice law in 2009, correct?
yes,
And then you were elected to the Pennsylvania House.
I was sworn in 2011.
Did you practice law in between that time, 2009, 2010, when you were elected?
Yes, and I continued to practice while I was in the House of Representatives.
What type of practice did you have?
I worked for a plaintiff's law firm doing civil litigation.
And then you were elected as judge in Washington County in 2017.
Yes, and then took office in 2018.
And at the time you became a judge in the Court of Common Pleas, did you have any experience trying criminal jury trials?
No.
Did you have any experience in handling sex assault cases?
Not as an attorney, no.
If you have the docket would reflect that a joinder notice was filed September 8th, 2021, which was after the arraignment date. So at that point, the cases were not joined, even though the Commonwealth had attempted to join them, correct?
You're correct in that they weren't joined in a proper time frame from what I remember. However, the cases were tracking together, and it seemed as if the previous conflict counsel and the public defender's office and the Commonwealth were running under the assumption they were joined, even though they may have been joined improperly.
So everybody was treating them like they were joined, but they were actually
Legally,
joined.
I don't think that they went through the proper procedure to legally join them based on the rules of criminal procedure, but everybody was running the cases as if they were joined.
Then on February 10th, you conducted that hearing that we talked about on the Commonwealth's motion to disqualify Mr. Wertz, right?
I think it was on multiple issues, but that was one of them, yes.
You ultimately disqualified Mr. Wertz, correct?
Yes.
When did Josh Carroll revoke his consent?
I don't know. I know that it was in the testimony when I asked him questions, but I don't know the exact time or date when he revoked his consent.
Do you know when Mr. Wertz received the revocation of consent?
No. I don't remember the exact time if it was testified to.
Do you know, you said multiple times, what did the testimony show about how many times Mr. Wertz spoke to Ms. Wheatley after he revoked the consent?
I mean, it would be in the transcript. I don't know the exact number of times, but I know that it was more than one.
During the hearing, Attorney Wertz testified under oath, correct?
Yes, I colloquied Mr. Wertz, and he did testify.
And he testified that his attorney-client relationship began with Ms. Wheatley on February 3rd, 2023.
His attorney-client relation, he was representing Ms. Wheatley? Is that what you're telling me?
That's what he testified to, didn't he?
I don't remember that.
He testified multiple times in the transcript that he began an attorney-client relationship with Ms. Wheatley in the PFA matter on February 3rd, 2023.
I know that he started communicating with Ms. Wheatley about the PFA, but Ms. Wheatley was already represented by an attorney in the PFA that did not withdraw their appearance. So I don't know if it was attorney-client relationship or what the communications were.
Did you ever, when you were disqualifying Mr. Wertz, did you ever seek Ms. Wheatley's testimony on the issue?
I don't recall. I don't remember if I did or not. I mean, she was represented by counsel and Mr. Carroll, but I don't remember if we attempted to get any testimony out of Ms. Wheatley or not.
You found in your findings that Mr. Wertz's conduct prejudiced Ms. Wheatley, correct?
Yes.
Wouldn't it have been important? Wouldn't it have been important for you, before making that determination, to know her position on communications with Mr. Wertz?
I didn't believe so.
Wouldn't it have been important to know if she believed that she had retained Mr. Wertz to represent her? Retained?
You went from attorney-client relationship to retained. So I'm not sure if at that point there was no document that I remember being retained from February 3rd. But no, what I found, Ms. Wheatley's position had no bearing on the disqualification.
After the February 10th hearing, on February 16th, 2023, you issued a subpoena to the Washington County Jail seeking recorded calls between Joanna Wheatley and Attorney Wertz, correct?
Yes, to preserve anything for these proceedings.
You understood those calls were attorney-client communications, right?
I had no idea what his calls with Ms. Wheatley were. Client relations, if properly done, are not recorded.
On February 16th, 2023, it reflects an order that you signed, right?
Yes.
And that it is hereby ordered that a subpoena duces tecum issue directed to the Deputy Warden of Washington County Correctional Facility, directing them to produce to this court any records and or recordings of telephone calls made between February 3rd, 2023 to present between inmate Joanna Wheatley and attorney Jeff Wertz that are held by them. This subpoena encompasses all such calls, and any calls that are blocked are hereby requested to be open for the purposes of this court.
If they had any information, we wanted to preserve it.
No, you asked them to produce recordings of telephone calls.
Produce recordings, not record. Like if they had anything that was recorded for the purposes of I was getting ready to write this letter. If there was anything that was going to be recorded, if it was recorded, then we asked for it. If it's not, we didn't ask them to record anything.
Well, it says this subpoena encompasses all such calls and any calls that are blocked. And those calls are blocked for recording, right? So by saying this subpoena encompasses all such calls and any calls that are blocked are requested to be opened for purposes of this court. So you are asking them to record blocked attorney-client communications.
Objection.
One, it's past tense, so no one's asking anyone to record anything in the future. It is strictly about preserving anything that was recorded.
You hadn't made the complaint at this point, had you?
So we were getting, it takes a while in the process of getting everything ready to do it.
You did it on March 22nd.
That's when I filed it. 900 criminal proceedings, and I have to write this letter. Didn't happen overnight.
Wasn't it that he was communicating with Ms. Wheatley and Mr. Jolliffe?
I assume, but I don't know.
Didn't we look at it this morning?
I didn't read the transcripts in preparation, read the documents in preparation of this.
You did not?
Sent to me. I did not.
Okay. Did Mr. Wertz ever, after his disqualification, enter an appearance or appear in court on behalf of Mr. Jolliffe or Ms. Wheatley in the criminal proceedings?
You mean actually stood at the bar and represented them?
Right, appeared in court on their behalf.
Well, I think he appeared in court. I don't know if it was on their behalf or not. I think he was in court after that, but I don't think he went to the bar and said anything on their behalf.
And he never entered an appearance on their behalf, right? After you disqualified him from the criminal proceedings,
No.
he never
No.
entered an appearance.
Not that I know of.
Did he? And he never appeared in court on their behalf.
No, he assisted Mr. Jolliffe in writing things that were filed.
Did the disqualification order prohibit Mr. Jolliffe from communicating with Mr. Wertz?
No, I think it says specifically representing.
Representing?
Mr. Wertz or Ms. Wheatley in the criminal matter, because I didn't have the civil matter was not my case.
Representing Mr. Jolliffe or Ms. Wheatley in criminal proceedings.
I think it even goes a little more specific than that relate to this. The criminal matters that relate to this. It may even give the case numbers. I'm not sure. But yes, the bottom line is it says representing. It doesn't say directly communicating.
So what was your authority for telling him not to communicate with Mr. Wertz?
We were getting close to trial, and the information that I received that Mr. Wertz was continuing to assist Mr. Jolliffe, I didn't believe was appropriate.
You don't know that he had any information from the co-defendant that he got after the consent was withdrawn, correct?
I know that now he's claiming he's representing her in a civil matter, so I don't know what information he has about the criminal matter. I have no idea.
You don't know that he had any information from Ms. Wheatley that he didn't have before the consent was withdrawn.
Objection
right?
asked and answered.
Sustained.
And you recused yourself in December 19th, 2023, correct?
I don't know the date, but if you tell me that's right, that's right.
That's all I have.